Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we turn our attention to Sarah Boone, the person on trial in Florida. You'll remember Sarah Boone. She convinced her boyfriend to get into a suitcase, and then not so much with letting him out again. And Sarah Boone is on trial for the murder. And she effed around and found out so hard, she lost her right to an attorney. But that will not dissuade Miss Boone from writing motions as herself, as now she is her own attorney. That's very exciting. So we will read her motions and the response that exists to them, and we will try to do them as well as they go. So let's go ahead and just get started. We begin with this motion. In the Circuit Court of the 9th Judicial Circuit, in and for Orange County, Florida, State of Florida plaintiff versus Sarah Boone defendant. Case number with the division number. She even makes it look in the right format. I respect that. She's putting things in the right space. I respect that. That's the way it looks. Temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial. You already have an investigator. That would be the person that already has existed and continues to exist, and the person who's making the copies of the thing to put onto the laptop as we speak. You have an investigator that's already being paid for. So I guess motion granted, I guess. All right. Comes now Sarah Boone, pro se, indigent defendant, respectfully requests from this court the reservation of proposed cost to acquire an investigator for defendant's defense in trial. Okay. I also, just personally, I don't like the whole comes now thing. It grinds my gears a little bit. Attorneys do it all the time, right? They start motions with comes now, the plaintiff or whatever. Don't like it. Don't like it. So, but you can't blame her. It's used by a lot of attorneys. It's fine. Just a personal pet peeve. I'm not a fan. But hey, she's using the right verbiage, even if I don't particularly like it. So that's fine. The investigator to be determined. It's not to be determined. I know the guy's name. I could go look it up. He's been appointed. He's the guy who appeared in court last time you were there. Total amount requesting to be determined. The state's already paying for this guy. How to calculate. Unknown by defendant. No discovery or case materials provided to defendant from the judge. Okay. Fine. This temporary motion is being submitted to meet the delegated due date of 7/24/20 or 27/22/24 by the judge in court as stated to defendant in the court order. $4.99 from Mandy Strong says, on your X post for the stream, I gave you the JAC response. Don't worry, I've got it. She's not getting standby counsel. I know she's not. Thank you very much for your super chat. They are extensively appreciated. The defendant is trying to avoid any further persecution and penalization from the judge and court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. Okay. The exceeded time limit of waiting to receive defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once defendant is finally received, they'll be able to proceed, will revise and resubmit this motion upon completion of other renewed and research upon the contents. It's a fair point. Pre-trial motions were due at a particular point, and she may not necessarily have everything necessary. In fact, she doesn't have everything necessary. She doesn't have the discovery. So how can she file the pre-trial motions? Because she doesn't necessarily have the things to file the motions against. There's a point to be had in there if a future appellate attorney wants to raise the issue. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests the honorable court to reserve any and all costs proposed to be incurred to acquire the investigator. You already have one. Motion granted. Defense requests are in good faith, and her merits are worth striving to successfully, lawfully, and properly perform, thrive, and overcome her forced by the court position of the pro se attorney and representation of oneself. But you already have one, though. You've had one for years. This investigator. He's been on your case for a while. I guess. Motion granted. I guess. Conclusion: this temporary motion for reservation of proposed costs to acquire an investigator for defendant's defense and trial should be granted. And then she gives an oath, declaring under the penalty of perjury that they've read the facts and believe them to be true. Cool. Fine. So, and then we have a certificate of service. That's cute. I hereby certify that original of this document has been filed via U.S. mail with the clerk of court of the 9th Judicial Circuit on this 18th day, and before the delegated due date by the court of July 22nd, 2024. I further certify that a copy of this original document can be e-served by a Florida court's e-filing system to all attorneys and other parties of record, which isn't how you do service, but, you know, it's fine. It's fine. She's pro se. And then she gives the address of the people to serve them and completed and mailed. Okay, fine. All right. Well, so far you got 1 for 1, Sarah. You got 1 for 1. Motion granted. You've got your investigator. Congratulations. I hope it really helps you out. Good luck. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, temporary motion for reservation of proposed cost to acquire expert witnesses for defendant's defense in pursuit of trial. Yeah, but you don't know who they are, though. That's going to be the problem. That's going to be the problem, that you don't know who the expert witnesses are. Now, again, you could try to make the issue that you don't necessarily know because you don't have the discovery, so you haven't had time to develop your case. There's issues to be had here. But we are where we are. So she might keep the appellate lawyers busy for a while. Could be fun. But she'd like an expert witness, paid for by the state. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire expert witnesses. And then you say to be determined. Well, no, that doesn't really work, because we need to know who the expert witness is so we can look at their CV, determine if they're going to be a suitable expert witness, and do all the rest of those things, and blah, 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 blah. So if you don't know who they are, that's going to be a problem. Yeah. Total amount requesting to be determined, how to calculate unknown by defendant, provided no reason, no discovery or case materials provided from defendant to judge. Fair. There's an appellate issue in there somewhere. She doesn't have the materials necessary to make a proper motion. There's an appellate issue in there somewhere. I respect that. This temporary motion is being submitted to meet the delegated due date of 7/22/24 by the judge in court as stated by the defendant in the order stated 6/28/24. Defendant is trying to avoid any further persecution and penalization from the judge in the court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery and case materials prompted by the court has forced them to submit this temporary motion. Fair. And if an attorney were somehow in this position, it would be exactly what the attorney should do, right? It's like, I don't know enough, but in order to preserve the issue and make sure that I'm not letting time periods lapse, it's like, yes, I mean, obviously as an attorney, you don't want to be in this position. If you're in this position, something has gone horribly, horribly wrong, right? If you're in this position, something has gone horribly, horribly wrong. But if you were in this position as an attorney, you would file a motion basically being, I don't know enough to know yet, but I know that there's a problem, and so I'm going to file it now with a right to amend later on the hopes that that gets me past my date. You know, that helps me get past my date, or at least I preserved the issue by giving as much information as I had. I did the best I could at the time under the circumstances. So I did my best to preserve the issue. So, hey, I'll give her credit. She's doing what an attorney would try to do in these circumstances. So she's not doing too bad for herself. I respect it. Her language is even respectful. Her language is fine, if perhaps a little bit, you know, defensive, but, you know, nothing wrong. It's fine by me. The exceeded time limit of waiting to receive the defendant's discovery and case materials forced the submittal of this temporary motion. Once defendant has finally received, she'll be able to proceed, will revise and resubmit this motion upon completion of her review. All right. I respect that. She's not going to get it, by the way. I respect it. The judge is going to give it to her, but, you know, she's preserving an issue for a future defense lawyer, or a future appellate lawyer someday, because she's absolutely getting convicted, right? We all know that, right? Just to go ahead, we all know she's getting convicted, right? So, you know, her future appellate lawyer, whoever that is, does have some workable issues here. So, I'm not sure it really gets you anywhere, but you can try. It's something. I respect it. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests the Honorable Court to reserve any and all costs proposed to be incurred to be acquired expert witnesses for the defense of the trial. By the way, incidentally, you don't need to do this because this is coming out of the state's funds, which are allocated by statute for these purposes. You don't need to reserve the money. You don't need to reserve the money. The money is there by law. So, yeah. But, fine. Technically, her first motion should be denied as moot. Whatever. Either way, it's fine. I don't care. But fair enough. Her first motion should be denied as moot. I guess. Yes, that's true. Fair point. Defendant's requests are good faith, and the merits are worthy in striking to successfully, lawfully, and properly perform, act, and thrive, and overcome or forced by the court's position of pro se attorney and representation of self. For a pro se, she's doing surprisingly well. This motion for reservation of proposed cost to acquire expert witnesses for defense should be granted. And then she files the oath with her signatures and her certificate of service with the addresses completed in mail. Hey, man, she's trying. She's trying. I respect that. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense at trial. Okay. So to the extent that these witnesses have to travel, then those expenses might have to be paid for by the state. All right. Fair, I suppose. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation, a proposed cost to acquire all witnesses needed for the defense, witnesses to be determined. And again, this is kind of a problem because you don't know who the witnesses are that you want. So if you named witnesses and be like, I want these witnesses, then, fair enough, but you didn't. So yes, Cape Cod Girl asks, who provides the law books to prison and how update are they? Every jurisdiction's differently. There's no particular guarantee of law books in prison, which is a real disadvantage if you're in prison because you may not have access to law books. You may not have access to a library, depending on the nature of the case. So, total amount requesting to be determined. No. How to calculate? Unknown by defendant. Reason. No discovery or case materials provided by the defendant from the judge. I'm not sure what witnesses I need. I'm not sure what experts I need. I haven't had time to go expert shopping. I don't even necessarily know, although this would be less likely, but I don't even necessarily know what expert witnesses my prior attorneys had considered hiring. That may or may not be information that was conveyed to her, genuinely, depending on where they were in the process, right? The attorney doesn't necessarily tell the client every thought that passes through their mind. And if they were in the process of trying to find expert witnesses, that may or may not be information she would necessarily know about. She may know, she may not know. And she may know some and she may not know all. Depends on what you do, right? This temporary motion is being submitted to meet the delegated deadline of 7/22/24 by the judge of the court as stated to the defendant in court order 6/28/24. Defendant is trying to avoid further persecution, penalization from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. Thank you, Judy M., for being a member for 10 months. We do appreciate all of our uncivilians. The exceeded time limit of waiting to receive defendant's discovery and case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received, she'll be able to proceed, will revise and resubmit the motion upon completion of her review and research of the contents. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests the Honorable Court to reserve any and all costs proposed to identify all witnesses. It would have been helpful, incidentally, if you had even tried to indicate what kind of experts you would want, even if not necessarily by name. That would have probably been helpful in terms of preserving the issue. Thank you, an honest doubter, for being a member for 18 months. We do appreciate all of our uncivilians. When does the trial start? It's early October. It's coming up soon. Defendant's requests are in good faith, and the merits are worthy in striking to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of oneself. All right. Motion denied, but we're trying with a certificate of service. It'll be interesting seeing the state respond to this. I wonder if they're going to respond in writing. I wonder if the state will respond in writing to these motions. That could be really interesting. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus Sarah Boone. Exciting. Temporary motion for depositions to be conducted per Florida rule, and I learned that last time when I burned myself last time, because when I see FRCP, I think federal rules of civil procedure, because that's the acronym for the federal rules of civil procedure. I'm like, we're not in federal court, but apparently Florida uses the exact same acronym for its state rules, and that should just not be allowed. That should just not be allowed. They should have to come up with a different acronym so that they're unique. That's not fair. That's not fair. They tricked on civil. We'd like depositions conducted per the Florida rules of civil procedure, or criminal procedure rather, Rule 3.220 by the defendant under pro se attorney title and position ordered by the judge and by the court. Comes now, Sarah Boone, pro se indigent defendant, respectfully request from this court for deposition to be conducted per FRCP Rule 3.220, defendant pro se and position ordered by the court, deponent to be determined. Again, you don't even know who you want to depose. But, of course, you don't have discovery. So there's that. Scheduled dates for deposition to be determined. Total amount requested for completion to be determined. Total amount requested for transcripts to be determined. How to calculate. Unknown by defendant reason. Defendant has been forced into the title and position of pro se attorney by the judge in court. Pro se attorney's request to take depositions and for defense, and no discovery or case materials have been provided to defendant. Fair. So you don't necessarily know who you want to depose. Although also depositions in criminal cases are rare comparatively speaking. I don't know Florida's particular rules. I'm sure Florida has rules that allow for it, but depositions are not the rule in criminal cases. They can be known to happen, but they're unusual in most cases. But then again, Sarah Boone's an unusual lady. So who am I to tell her how to best practice her case? That being said, however, interviewing a witness is not uncommon, although that wouldn't necessarily be a deposition. It would potentially be more informal, because both parties have the right to ask any witness to meet with them. The witness can say no, but they have the right to ask, and they can do that. And you saw that in My Cousin Vinny, where My Cousin Vinny went around and talked to the witnesses in advance of the trial. That's perfectly legal. He can do that. He has the right to go talk to them if they want to talk to him, and he can compel their testimony once they're on the stand. But yeah, you can do that. You can do that. That's fine. Mandy Strong from 499 said, it's funny how smarty pants Sarah forgot to file a motion for continuance. Yeah, that's a good point there, Mandy. That's rough. That's rough. Got to file that motion for continuance. You really should have filed the motion for continuance on the basis of, I don't have discovery, so the clock should reset. Yeah, I feel you, man. I feel you. Florida Rules of Criminal Procedure 3.220, discovery. Discovery deposition states generally, at any time after the filing of a charging document, any party may take the deposition upon oral examination of any person authorized by this rule. Cool. In any case, no person shall be deposed more than once, except by consent of the parties or by order of the court issued on good cause therein. A witness who refuses to obey a duly served subpoena may be adjudicated in contempt of court from which the subpoena is issued. The defendant may, without leave of court, take the deposition of any witness listed by the prosecutor as a Category A witness. So she has the right to take deposition of all those witnesses. That's interesting. After receipt by the defendant of the discovery exhibit, defendant may, without leave of court, take the deposition of any unlisted witness which may have information related. For witnesses, she could have just literally said every single prosecution witness. All of them. She could have just said it that way, and that would have identified them. But maybe that's implicit. I don't know. Discovery sanction states that if any time during the course of the proceedings, it's brought to the attention of the court that a party has failed to comply with applicable discovery rule or with an order pursuant to an applicable discovery order, the court may order the party to comply with discovery or inspection of materials not previously directed or produced, grant continuance, grant a mistrial, prohibit the party from calling the witness not disclosed or introducing the evidence, the material not disclosed, or under such other order as it deems fit. Yeah. So in response to discovery violations, this is pretty standard language. The court has its available panoply of remedies. Available panoply of remedies. And these remedies can be like, you can't use that evidence. You can't call that witness. You can't ask that question. We'll give you more time. Or, dismissal. F around and find out, right? So these are some of the many things that are on the table, potentially for sanctions, for late discovery, late disclosures, which is fair enough. You got to we don't do ambush, man. We don't do trial by ambush. So if you don't get it in time, it may not be fair. Fine. Willful violation by counsel or a party not represented by counsel of an applicable discovery rule or of an order pursuant to thereto shall be subject to counsel or unrepresented party to appropriate sanction by the court. The court has jurisdiction when you feck around. The sanctions may include, but are not limited to, contempt proceedings, the attorney or unrepresented party, as well as the assembly assessment of cost incurred by the opposing party when appropriate. So we can give you sanctions against the other party. We can also give you money. We can pay for your attorney's fees as a possible sanction. This temporary motion is being submitted to meet the delegated deadline. The defendant is trying to avoid any further prosecution and penalization. We've read this language. Holla. Good times. 420 in chat. Good times. You wish I volunteered. I'm pretty glad right now I didn't, to be quite honest. Wherefore, Sarah Boone, indigent defendant, respectfully requests this court to allow depositions to be conducted per the rule by defendant under pro se attorney title and position or by the judge in court and for a defense in the case and trial. The only thing she could have really done here would, because apparently, according to the rule, the way I read it, she's entitled to a deposition of any named witness by the prosecution. So rather than to be determined, she should have written every single witness. She should have just written every single witness designated by the state under the rule. That would have been better. That's quite going on. Yeah. Not bad. She's surprisingly giving her future appellate attorney some things to work with. And I appreciate that. I appreciate this she's giving her future appellate attorney some things to work with. Okay, that's the end of that document. Let's look at the other document. We have more exciting motions. Incomplete. So that was document number 1, which had 4 exciting motions on it. Document number 2. In the Circuit Court of 9th Judicial Circuit in and for Orange County, Florida, motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. Okay, different states deal with standby counsel, generally speaking, but generally speaking, you don't have a right to it. The court may, in some jurisdictions, appoint one, but that's mostly out of a courtesy to the court or because of other considerations. But I don't know if any jurisdiction requires it, and it certainly seems to be the trend to not do it. But that seems to be the trend. But it is a thing that the courts can do. At least they have historically. How much today? Who knows? I mean, maybe some states have abrogated it completely by statute. It's like, which should be fair enough, right? If you're pro se, if you're yourself, then you are your own attorney, and good luck to you. So, yeah, but if she's not entitled to one by statute, which presumably she's not because the court didn't appoint one, then she's probably toast. But I do appreciate her asking. Unless she's going to quote a relevant rule or something. That'd be exciting. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her fit for the right to counsel by the court as a pro se attorney and in her proposed lawful representation of self in her criminal case. Defendant's justifiable reasons for request of relief and assistance are as follows. Defendant's Sixth Amendment right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant whole under false pretenses, speculation, libel, and misconstruction. No. As much as I appreciate your efforts, just no. The representations that caused the judge to do it were made by the attorneys themselves in open court. Not so much with the speculation as much as we are unable to work with this lady. We can't get it done. I can't make it work, Your Honor. I tried. I really did. I tried. No, but I do appreciate your efforts here. But no. By the defendant's lawful practice of her entitled First Amendment constitutional right of freedom of speech. Yeah, you might have freedom of speech, but even attorneys are protected by the 13th Amendment, Sarah. And her God-given right to do so by writing her experience, derived truth, and providing red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively, advance fairly and unrestrictedly, while having reliability to be leveled equally with the prosecution. You're going to get crushed, Sarah. You're going to get crushed hard. The defendant is not an officer of this court. That's true. Or any court or legal system of a whole. She is not bound lawfully under oath or certification in any professional means to be or acted as legal agent or representative, lacking requisite professional competence, experience, expertise in the field of law presently and historically. Yeah. Oh, well. Yeah. Emotional damage.
Emotional damage.
Yeah. And the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and her ability to complete tasks and timely responsibilities suitable to the vital defense. Yes, being in jail kind of means you are restricted somewhat. You're kind of restricted somewhat because you're in jail. Boy, oh boy, probably should have tried to scare away all those attorneys, man. You know what I mean? Yeah. By the court rejecting professional, educated, experienced, and with the effective assistance counsel, well, it's not so much the court rejecting it as the professionals themselves rejecting it, because the court was all happy to appoint them. And the professionals were like, no, that's okay, we're good. So yeah, by the court rejecting, which isn't what happened, professional, educated, experience, aid, and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair disadvantage, oppressive circumstances to properly thrive in a forced position by the court of pro se attorney. Yeah, maybe you shouldn't have effed around so hard. Examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include: defendant has not received from the court to date of this motion any of her promised discovery or case material submitted by former attorneys to the court during the unannounced hearing, which is fair enough. You know, she does not have her discovery and she can't use it for preparation of her motions. She can't use it for preparation of her deadlines. She really should have filed for a continuance, ma'am. She really should have filed for a continuance. With only 4 days to submit my demands and motions delegated by the court. That's a fair point. Defense has not reviewed from the court to date of this motion any of her promised discovery or case relay material submitted by the former attorney to the court during the unannounced hearing. With only 4 days to submit my demands and motions delegated by the court on or before 7/24, defendant does not have access to a computer. Defendant does not have access to the internet. Defendant has been extremely limitedly irregular access to basic tablets provided by the police department. Defendant has access to payphones for collect phone calls only, limited to 15 minutes. Defendant does not have access to organizational supplies or production equipment, copier, printer. Defendant does not have access to meeting place for privacy in case review or preparation. Additional daily obstructions and undetermined hardships, disabilities will likely come about due to being incarcerated and once my case materials are finally received. Continued application in reasoning and further lawful support of defense requests for immediate relief with standby counsel aid and assistance in preparation for case. You know, this is actually pretty good. I have to give credit. This is pretty good. You know, this is pretty good. I've seen attorneys write worse. I've got some respect for you, Sarah. Yeah, I got some respect. You might have missed your calling as a lawyer. You know, with a little bit of training and a little bit of practice. I mean, you know, for your first attempt, because it's your first time ever doing it, this is pretty good. This is pretty good. I mean, I wouldn't be completely embarrassed by filing this. I would have made some slight changes, obviously, but you know, I respect this. This is actually really decent. It's making me surprisingly happy how good it is. It's fine. I've seen a lot of pro se stupid. This is pretty good for pro se. It's good. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by impartial jury of the state and district where the crime has been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against them, to have compulsion process for obtaining witnesses in their favor, and to have the assistance of counsel for their defense, quoting Amendment 6, holla. Right to counsel is assured by the Sixth Amendment, but of course, like any amendment, you can forfeit your rights. You know? Damn. Which means it's been incorporated in due process. Wow, who taught her about incorporation doctrine? Who taught Sarah Boone about incorporation doctrine? Wow. I'm impressed. Maybe Sarah Boone, if she gets off, she can be my new paralegal. Right to counsel is assured by the Sixth Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment, as well as the state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance and counsel at each stage of the criminal proceeding and process. Oh, she's quoting a law dictionary. I'm still impressed. She's quoting a law dictionary. I'm still impressed. I mean, she knew what to look for. She knew what to write down. I mean, you know, hey. Right to counsel applies where a defendant can afford to hire a lawyer or not, true, in which case the court will appoint a lawyer. And citing right to counsel in Beauvoir Law Dictionary, not Black's Law Dictionary, so necessarily inferior law dictionary. Is necessarily inferior law dictionary. Andrew says, still here for the uncivil legal mindset defense team coming to Boone's rescue. Andrew would need to give me a lot of help, man. Although that would be hilarious. Andrew, can you help write some of my motions? Waiver of counsel is a criminal defendant's refusal of counsel at any stage in criminal process. I've never refused. No, you effed around. It's been made by a person with full capacity, unprepared, that is knowing involuntary, forced. Yeah, you didn't waive it. You forfeited it, which is a slightly different concept, which comes up in other aspects of law. Incidentally, this also comes up in appellate issues with waived arguments versus forfeited arguments. In terms of arguments that were waived below versus forfeited below, sometimes that makes a difference on whether or not you can bring it up in an appellate argument. It can get strange sometimes. It can get strange sometimes, but you knew that because you watch this channel. You know it can get strange sometimes. I didn't have to tell you that. And clearly and unequivocally rejects representation or assistance by attorney at law during pending proceedings, citing Beauvoir's Law Dictionary. I guess they don't have Black's Law. They have inferior law dictionary. Lame. She cited her source too. That's fair. She cited her source, and it's all she has, presumably. She doesn't have Black's Law Dictionary. So, you know, I can't fault her. You know, it's inferior law dictionary, and I'm going to mock it a little bit, but she did cite her source. I appreciate that. Her citation isn't up to Blue Book form, though. So tisk, tisk, tisk. A defense decision to waive her right to counsel must not only be competent, but also knowing and voluntary. Maynard versus Boone, with a pinpoint site with the case and date number. Holy shit. Holy shit. That is proper form. Holy shit. Nice. The right to waive counsel forced by the court is the right knowing to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record, taken in its entirety, shows the defendant comprehends the waiver of counsel, that they will proceed in the labyrinth of law without the assistance of an obtained guide. Yeah, but we're not talking about waiver, we're talking about forfeiture, which is a related but not necessarily the same concept. Robin says, remember to only bring carry-on, no suitcases. Dude, man, I'll tell you what, I'm getting the suitcase or one exactly like it, and I'm going to try to crawl into it in the middle of the court proceedings. And when I can't do it, I say, if the suitcase doesn't fit, you must acquit. It's going to be fantastic. The counsel's going to object to everything that's happening, and it's going to be great. The court must first make inquiry into competence and be reasonably satisfied if before accepting the accused waiver of counsel never gave. Competence means more than a minimum of mental awareness and capability. However, it involves an intellectual conception of the consequences of the acts. No one explained to me. That's not true. They did explain it to you, just weren't paying attention. Michigan versus Holcomb, 47 Mich App, 573, 584, 1973. Now, I'm assuming that there's more than one Michigan appellate court. So in the proper citation, you would include which appellate court, like the second appellate court or which appellate court it came from. So I don't think that's correct, but we'll do what we can. At least I can find it. At least I can find the citation. So that's nice. The trial was a farce or a mockery of justice or was shocking to the conscience of a reviewing court. The purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. People versus Dallin-Garvrade, 19 Mich App, 702, 173 Northwest, 317. That is in proper form. Also, for what it's worth, of course, those are Michigan cases. So, Michigan is not Florida, but, persuasive authority. She's trying, bless her heart, she's trying. And as an attorney, I would absolutely cite authority from outside my jurisdiction, particularly if it's all I had to work with, which is sometimes the case. You cite the best authority you can for your proposition. If all you've got is authority from outside the jurisdiction, you do what you can, man. You do what you can. So, hey, fair enough. Ineffective assistance of counsel is both a standard of inadequate performance for a lawyer in a criminal representation and failure of due process of the law to the criminal defendant. A person who has suffered a punishment in a civil proceeding, I was repeatedly lied about by my former attorneys to the judge, who was unjustly believing all over me. Well, yeah, the judge is going to probably believe them all more than you. Yeah. 499 from Mandy Strong. She could have the prosecutor zip her up in the suitcase and Sarah can show how to get out of it. Love it. Love it. Good. Good stuff. Love it. Thank you, Mandy, for the super chats. Your super chats and support do please me. Thank you. I appreciate your love. I appreciate your support. It's very kind. Thank you. Let's see. And we do appreciate everyone who hits that beautiful, beautiful join button. For only 99 cents a month, you too can become an uncivilian to help support the channel financially by hitting that beautiful, beautiful join button. You get some emojis, you get some scales by your name. It's great. A person who suffered, okay, we read that part. Where are we picking up this? Okay. by the judge who's unjustly believing all over me, falsely accusing me of inappropriate and wrongful strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel, to which there's a right of counsel, but to who receive ineffective assistance is ordinarily entitled to a new proceeding with adequate representation, as long as there is a reasonable probability that the result might have been different if the person had received adequate legal proceedings. Respect. Thank you, Kissy Kissy, for the 10 gift memberships. They are extensively appreciated. Thank you. And thank you to everyone watching me, by the way, on all the platforms. If this is working properly right now, and I really hope it is, this is being broadcast on YouTube, Twitch, X, Facebook, and LinkedIn. So if you want to subscribe to me on LinkedIn, I think that's a possibility. Due to ineffective assistance of counsel, the federal courts in 1999 set this second sentencing aside, citing Smith versus Arizona, 128 S Court 2997, 522 U.S. And then it says 9851, which is definitely not correct. But, good for trying. Florida Constitution, the 2024 edition. Article 1, Declaration of Rights. Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty, to pursue happiness. Section 4, Freedom of Speech and Press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and all civil actions for defamation, the truth may be given in evidence. If the matter charged as defamatory is true and was published with good motives, there's no way this is from the Constitution. There's no way this language is from the Constitution. This is too informal. If the matter charged as the defamatory is true and was published with good motives, defendant writing truthfully, lawfully letters to the court requesting help with the function of attorneys, then defendant is unlawfully forced to forfeit her right to counsel from lies, misinterpretation, and ineffectiveness from those former attorneys. Retaliation from the court, the party, defendant, shall be exonerated, given appointed counsel, which, by the way, isn't what exonerated means. Section 5, right to assemble. The people shall have the right to peacefully assemble without harm, to instruct their representatives, and to petition for redress of any grievances. Cool. Section 9, no due process. No person shall be deprived of life, liberty, or property without due process of law, or twice be put in jeopardy for the same offense, or compelled in any criminal manner to be a witness against oneself. Cool. Section 16, right of the accused. In all criminal prosecutions, the accused shall, upon demand, be informed upon the nature and cause of the accusation, and shall be furnished a copy of the charges, and shall have the right to compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by an impartial jury in the county where the crime was committed. Neat. Section 21, access to courts. The courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Okay. The 14th Amendment to the Federal Constitution declares, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside, which is my personal favorite little tidbit from the Constitution, because it's correct to say that you have state level citizenship. I mean, most people don't typically think about it that way, but the 14th Amendment just told you did just now, right? It's like it just said you do. You are citizen of the United States and of the state in which you reside. So I'm both a citizen of the United States and a citizen of Texas, because that's the state in which I reside at the moment. So I'm a citizen of Texas. That is a completely true statement. So one of my favorite little Easter eggs, I guess, from the Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. Good times. This provision has often been construed by the United States Supreme Court and has been uniformly held that due process of law requires ample notice to the accused and sufficient time to secure counsel and preparation for trial, which arguably you've had. But maybe arguably not. I mean, there's something in there somewhere. A like rule as to necessity for due notice and reasonable opportunity to prepare for defense is declared in Franklin versus State of South Carolina. 281 U.S. 161. In Rogers versus Peck, 199 U.S. 425. In Hooker v. Los Angeles, 188 U.S. 314. In Louisville and Nashville versus Smith, 177 U.S. 230. And in other cases. She's citing authority. I mean, it's something. Such notice was not reasonable one, was not due process of law within the 14th Amendment to the Constitution of the United States, and judgment obtained by such notice was not binding on the defendant. This is 6 RCL page 446, I guess, states that essential elements of due process of law are notice, opportunity to be heard, and to defend in orderly proceeding adapted to the nature of the case. Yeah, that's basically correct. Notice and opportunity to be heard. That's basically due process. And then after that, kind of depends on the thing we're talking about. And of course, due process can be after the fact in some situations. For example, you park on a city parking lot and your car is illegally parked. So they tow you and they've deprived you of your car because it's now in a car impound lot, right? You're still entitled to due process in this situation. You're entitled to due process after the fact. So you can take the city to court and be like, you can tow my car. And, you can have that fight. But okay. The term due process of law, when applied to judicial proceedings, means a course of legal proceedings according to the rules and principles which have been established by the jurisprudence for the protection and enforcement of private rights. Panover versus Neff. Respect. 95 U.S. 714, 715. With the pinpoint site. With the pinpoint site. That second page number is called a pinpoint citation, by the way. 714 is the first page on which the opinion appears. The next one is the specific page on which the principle can be found from. It's called a pinpoint cite. And I'm in love. I'm in love. We have pinpoint citations, people. It's great. The accused cannot be deprived of his life, liberty, or property unless by the judgment, 298 PA 173, which I'm assuming is the Supreme Court of Pennsylvania, but you would normally make that clear, of his peers or the law of the land. The law of the land, like due process of law, requires timely notice and opportunity to defend. You've had timely notice and you have an opportunity to defend. So yeah, it is vain to give the accused a day in court with no opportunity to prepare for it. Ooh, that's something. I like it. This is good. It is vain to give the accused a day. This is good legal research, Sarah. This is good legal research. I'm feeling it. I'm feeling it. I'm feeling it. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts or law of the case. Every man is presumed innocent and, when accused, entitled to a reasonable opportunity to prepare for the defense. Citing presumably the Supreme Court of Pennsylvania in Commonwealth versus Quell O'Keefe, 298 PA 169, PA 1929 is presumably the Supreme Court of Pennsylvania. But hey, I'm here for it. I'm here for it. It is true that the great inexcusable delay in enforcement of our criminal law is one of the gravest evils of our time. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not have been stripped of his right to have sufficient time to advise with counsel and prepare for the defense. To do that is not protected promptly in the claim spirit by those regulated of justice, but to go forward with the haste of the mob. Respect. Respect. David asked, citing a PA case in Florida? Sure. It's citing it's persuasive authority. So yeah, lawyers will do it all the time. Lawyers cite from cases outside the jurisdiction all the time. It's persuasive authority. It's not a Florida case. It's not binding. It's not controlling authority. But hey, it's persuasive. So hey, lawyers do it all the time, and I'm thrilled for it. I'm here for it. An affirmation of the right to aid and counsel is a petty offense, and its denial in case of crimes of the gravest character, where such aid is needed most, is so outrageous and so obviously of a perversion of all sense of proportion. Recognizing that the rule was settled at common law, denouncement it as not keeping with the rest of the humane treatment of prisoners. For upon what face of reason can that assistance be denied to save the life of a man, which is yet allowed to him in the prosecution for every petty trespass? Nice. How can a judge whose functions are purely judicial effectively discharge the obligation of counsel for the accused? Fair. He can and should see to it in the proceedings before the court the accused shall be dealt with justly and fairly. He cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and the accused, which in this case is the same thing, which sometimes partake of inviolable character of the confessional. Respect. Article 5 declared that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Fair. Each person charged with treason, murder, felony, or other capital offense should be admitted to make full defense by counsel learned in law. Notice and hearing are preliminary steps essential to the passing of an enforcement judgment, and they, together with a legally competent tribunal having jurisdiction over the case, constitute basic elements of the constitutional requirement. Are you sure they have jurisdiction, Sarah? Are you sure the court has jurisdiction? Are you sure you don't want to go with grounds? Grounds? No? Okay. So often quoted by the law of the land is instead a law which hears before it condemns. Judgment without such citation, an opportunity once of all the attributes of a judicial determination. If it's judicial, usurpation and oppression, and never can be upheld where justice is justly administered. Fair. Even the intelligent and educated layman has a small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence, let alone without an aid of counsel. He may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the time at issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he may have a perfect one. He requires the guiding hand of counsel at every step of the proceeding against him. Without it, he may not be guilty. He faces the danger of conviction because he does not know how to establish his innocence. If that be true of man of any intelligence, how much more true of the men who are ignorant? In any case, civil or criminal, a state or federal court were to arbitrarily refuse to hear a party by counsel, it reasonably may not be doubted that such refusal will be denial of a hearing of competency and therefore due process. Yeah, but it wasn't arbitrary though. Pretend judge gives $2. Thank you very much for the super chat. Yeah, when will subject matter jurisdiction be proven for the record? When will subject matter jurisdiction be proven for the record? Unclear. Unclear. You feel like Sarah will take the stand in her own defense? I'm sure of it. I have very little doubt in my mind. I have very little doubt in my mind that Sarah will take the stand in her own defense. It's gonna be good popcorn fuel, people. It's gonna be good popcorn fuel. Pointing to the fact that the right to counsel is secured by the Sixth Amendment relates only to criminal proceedings, which is true as far as it goes, Judge said, but it's equally true, the provision was inserted in the Constitution because the assistance of counsel was recognized as essential to any fair trial of a case against a prisoner. In ex parte Riggins, CCA 134F period 404. CCA, what would that be? This is the first federal reporter. Is this some sort of like circuit court thing that doesn't exist anymore? Yeah, I'm not sure what CCA is. I'm thinking it's probably like the old courts of appeal before they revised them into the system we know now. Anyway, it's just an aside by me. A case involving due process clause of the 14th Amendment, the court said, by way of illustration, that the state should deprive a person, also it doesn't give a year, I'll note, if the state should deprive a person of the benefit of counsel, it would not be due process of law. Judge Cooley refers to the right of petition, accused of a crime, to have counsel as perhaps his most important privilege, and after discussing the development of the law on the subject says, with us is the universal principle of constitutional law, the principle of the constitutional law that the prisoner shall be allowed defense by counsel. Yet you were allowed that 9 times. 9 times, Sarah. 9 times. 9 times, Sarah. Shaking my head, man. Shaking my head. The necessity of counsel was so vital and inoperative that the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process within the meaning of the 14th Amendment. All that is necessary now to decide, and we do decide, who the defendant is unable to employ counsel and is incapable adequately of making his own defense because of the ignorance, inexperience, or the like, it is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of law. Pretend judge gives $2 to say, never fear, I am here. My fear is satiated. Pretend judge. My fear is satiated. And that duty is not discharged by assignment at such time or under such circumstances as to preclude the giving of effective aid in the preparation and trial of the case. To hold otherwise would be to ignore the fundamental postulate already adverted to, that there are certain immutable principles of justice which inhere to the very idea of free government, which no member of the Union may disregard. Holden versus Hardy, Supra. Who taught her? Wait a second. First of all, did she cite Holden versus Hardy? I don't think she did. I think that's a bad Supra. Did she cite Holden versus Hardy before? Because Supra means above. She didn't cite it. She just copied it verbatim out of the book, didn't she? She didn't cite Holden. Did she? I don't think she did. She's copying Powell versus State of Alabama, 287 U.S. 45. Okay, noted. I mean, the language is pretty great, so I'm not surprised it's the U.S. Supreme Court. I mean, you know, this is pretty high philosophy. This is the kind of thing I like, right? This is reaching for the utmost in the Constitution. This is reaching for the utmost of it. This is a philosophical reaching for the stars, and that's why I'm here for it. So I'm not surprised it's the U.S. Supreme Court, because this is like Supreme Court at its best. This is great. We could check Black's Law Dictionary. Should we check Black's Law Dictionary and see what CCA is? It must be in my dictionary, right? There's a reason I keep this thing on my shelf, right? There's a reason I keep this thing on my shelf, right? Let's see if Black's Law says what CCA is. Let's see. C. Do 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 do. Ba ba ba. Do 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 do. C. A. Nope. Well, CC is a circuit court. That makes sense. but it doesn't have CCA. So Black's Law Dictionary is of no help. Lame. CCA, what is this? Court listener CCA? Circuit Court of Appeals records. Circuit Court of Appeals. Yeah, this is the old circuit courts, right? Yeah, this is the old circuits, CCA. Yeah, United States Circuit Court. Yeah, pre-1912. So CCA is Circuit Court of America. Yeah, so CCA is referring to the circuit courts as they existed between 1789 and 1912. So this is the old circuit court. These are the courts. These were the circuit courts, which is distinct from the Court of Appeals today. So that's what CCA is. It's referring to the old circuit courts. Cool. Neat. That's what I said in the first place. That's why I said I think it was an abbreviation for some sort of appellate thing. So I was right. It's like I couldn't quite come up with it, but I was right. All right, let's see. Those stopped in 1918. Yeah, that's right. Congress passed the Judiciary Act and redid the entire organizational structure of the appellate courts in 1918. So, yep, that makes sense. All right, let's see. To have otherwise would be to ignore the fundamental postulate already averred to. The right to counsel be appointed when necessary is a logical corollary from the constitutional right to be heard by counsel. Compare Carpenter and Spagate versus Dane County, 9 Wisconsin 274, Dane County versus Smith, 13 Wis 585, 586, 80 Am Deck. I don't know what that is either. 754. Hendricks v. State, 130 Indiana, 265, 268, 269. It's a very weird string site. Normally you would just write that 265, 268-269, but whatever. 29 Northeast Reporter, 1131. Cutts versus State, 54 Florida, 21. 23. 45 SO, don't know what that is, 491. People v. Goldston, 76 Cal, 328, 344. 19 P something, 161. Don't know that one. Derek, these are abbreviations to reporters I don't know. This is apparently what we're doing now. We're testing on civil and abbreviations of reporters he doesn't know. This is great. Deck v. State, 99. I guess CA 667, 669, 670, although dash would be more traditional. 26 SE Southeastern Reporter 752. In Hendricks versus State Supra, there was no statute authorizing the assignment of an attorney to accomplish the ends of public justice, and the court possessed the inherent power to make it. Where a prisoner, the court said, page 269 of 130 Indiana, 29 Northeast, 131, 132. No, that's wrong. Because it can't be page 296. Because the opinion starts on page 1131. So it can't be page 296. You cited the wrong place, Sarah. That's a point in demerit. Without legal knowledge, is confined to jail, absent from his friends, without the age of legal advice or the means of investigating the charge against him. It's impossible to conceive of a fair trial where he's compelled to conduct his cause in court without aid of counsel. Such a trial is not far removed from an ex parte proceeding. Let us suppose that the extreme case of a prisoner charged with a capital offense, unable to employ counsel, with the whole power of the state arrayed against him, prosecuted by counsel for the state without assignment of counsel for his defense, tried, convicted, and sentenced to death. PBL. What is PBL? What is PBL? Is it a kind of sandwich? Is it a tasty treat? Black's Law Dictionary doesn't have that one either. I'm being let down by Black's Law Dictionary right now, I have to say. I'm disappointed. Such a result would, if carried into execution, be little short of a judicial murder. It cannot be doubted would be a gross violation of the guarantee of due process law, and we venture to think that no appellate court, state or federal, would hesitate so to decide. See Stevenson versus State, 4 Ohio App 128, Williams versus State, 163 ARC, 623, 628, 260 Southwest 721, Gorgon versus Commonwealth, 222 Kentucky, 484, 485, 1 Southwest, really? 1? Wow. Okay. 1 Southwest, second edition, 779. Mullen versus States. I mean, you don't see first volume very often. That's unusual. Although I did have that happen when I was working on the Supreme Court brief. What was it I was citing in volume 1 of? It was the federal statutes at large. That was pretty hilarious. When I were trying to, because I was trying to, I was like, you know, when you're fighting the federal statute law and you're in volume 1, you know, federal statutes at large are everything Congress has ever written. And so you're in volume 1, you know, you're kind of early in the history of the American experience. So good times. The legislature has become so thoughtfully convinced of the impropriety and injustice of shackling, and restricting a prisoner with respect to the defense that they abolished all their odious laws, and every person which is accused of a crime is entitled to every possible privilege in making his defense and manifesting his innocence by the instrumentality of counsel and the testimony of witnesses. Powell versus Alabama, 287 U.S. 45, 53. And then they cite other reporters, which I don't personally like that either. It's like, just cite the U.S. reporter like a normal person. But yeah, sometimes you'll see like these reporters to Supreme Court cases where it's other Supreme Court, there are other reporters. It's like, just use the U.S. reporter. Just give me, I don't need to know what other reporters it's in. Just give me the U.S. reporter. It'll be fine, you know? So I'm not really like a fan also, as long as we're like, I'm not a fan of these. This is a triple citation. This is a triple citation. These are 3 different reporters. I don't need 3 reporters. 1 will be fine. I'm just saying. 1 will be fine. And you got to pick the one U.S. 287 U.S. 45 was enough. Thank you very much. In a long line of cases that includes Powell versus Alabama, 287 U.S. 45, 53. And then again with that Supreme Court, which is different quarter, and then LED, different reporter. Johnson versus Serhart, 304 U.S. 458. And Gideon versus Wainwright, baller case, 372 U.S. 335, 1963. This court has recognized the Sixth Amendment right to counsel exists and is needed in order to protect the fundamental right to a fair trial. The Constitution guarantees a fair trial through the Due Process Clause, but defines the basic elements of a fair trial largely through several procedural protections of the Sixth Amendment, including the Counsel Clause. Neat. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Neat. Thus, a fair trial is one in which evidence subjected to adversarial testing is presented to an impartial tribunal for the resolution of issues defined in advance of the proceeding. The right to counsel plays a critical role in the adversarial system embodied in the Sixth Amendment. Six, access to counsel skill and knowledge is necessary to accord defendants ample opportunity to meet the case of the prosecution to which they're entitled. Abrams versus State, ex rel. McCain, 317 U.S. 269, 275, 276, and with some other citations. Because of this vital importance of counsel's assistance, this court has held that with certain exceptions, a person accused of federal or state crime has the right to counsel appointed if retained counsel cannot be obtained. See Arsinger versus Littman. I don't know that case. Gideon versus Wainwright. Holla. Johnson versus Zerbite. That person who happens to be a lawyer is present at trial alongside the accused, however, is not enough to satisfy the constitutional command. The Sixth Amendment recognizes the right to assistance of counsel because it envisions counsel playing a role that's critical to the ability of the adversarial system to produce just results. An accused is entitled to be assisted by an attorney, whether retained or appointed, who has played the role necessary to ensure that the trial is fair. For that reason, the court has recognized that the right to counsel is the right to an effective assistance of counsel. And then we have some more citations, which I think I'm going to stop reading at this point because I'm getting tired. But she keeps citing case law for a while. And finally reached a conclusion. This motion for immediate relief by appointing effective assistance by counsel for support of her rights should be granted. No, but thank you for playing. Anyway, Chuck in Tennessee, thank you for being a member for 21 months. We do appreciate all of our uncivilians. And then we have the letter. Cool. And then finally, we have a response from the Judicial Administration Commission. Let me make the margins a little bit better since we have a new document. So we have a response from the Judicial Administration Commission. Comes now. They also believe in the comes now thing. I could do without it, please. The Justice Administration Commission, by and through undersigned attorney, files this response to the above cited motions as follows. The defendant is seeking authorization for various due process costs as follows. Appointment of standby counsel to assist defendants, costs to take depositions, and unspecified amounts for defense investigator, unspecified expert witness to assist the defense, costs for unspecified witnesses to appear at trial. As an initial concern, any future requests for due process costs, such as requests for transcripts, investigative costs, or experts, need to be served on JAC prior to the court considering the matter, because it's coming out of their money. The defendant is responsible for providing JAC with any motions for due process costs, so JAC can respond accordingly. JAC may only pay for due process costs pursuant to statute. Okay? As directed by Section 27.4525 Florida Statutes and the General Appropriations Act, all due process services are subject to Florida statutes and JAC's contract policies and procedures. They object to any compensation rate in excess of the established rates, which is fair enough. As to standby counsel, as for the appointment of standby counsel, the court entered an order on June 20th, 2024, finding the defendant had waived, strictly speaking, forfeited her right to counsel through the conduct of the matter. Thus, the court has already ruled on the issue. Deposition-related costs. As to costs relating to deposition, defendant is authorized to incur costs to take depositions for those depositions authorized under Florida Rules of Criminal Procedure. The notice taking deposition substitutes for the court order for the purpose of the court reporter seeking compensation for the appearance fees. As to service of process, service must be paid through the sheriff unless the sheriff is unable or unavailable to produce service. In those instances where private service of process is necessary, a separate motion to incur costs for the private process server will be required. The sheriff must be used for in-county law enforcement. As for transcripts, JAC has no objection to regular paid rates. The motion for order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing, and recording tape and date of recording. Defendant should only request order those transcripts necessary for the defense. The uniform statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. As to the private investigator, pursuant to uniform state rates, the rates for these investigators cannot exceed $50 an hour. As required by federal law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by an investigation agency with a Class A license. So some states require licensure, and Florida is one of them. If the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears that prison break investigator Billy Lane may have already been appointed to this matter. JOC does not object to the court authorizing $5,000 for a defense investigator and $500 to investigate to obtain case-related documents and materials. So fair enough. As to expert costs, based on JEC records, the court previously approved a $3,000 at a rate of $200 per hour for a defense mental health expert, which is not very much for an expert, to be quite honest. JEC does not object to the court continuing that authorization now the defendant is representing herself. If you can find an expert for $200 an hour, let me know. That's pretty low ball money. I'll do it, I guess, but I'm not sure I'm qualified. As to requests for other experts, the defendant will need to fill in an appropriate motion delineating the following: identifying or type of expert, amount authorized for expert services, and rate authorized for the expert services. Defendant has the burden to show the particularized need for the witness. The defendant needs to show the services of the expert are necessary. As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish the particularized need for the due process service and prejudice arising from the denial of the due process service. The determination of whether to appoint an expert is within the broad discretion of the court. An indigent defendant must show the trial court there exists a reasonable probability both that the expert would be of assistance to the defense and denial of the expert would result in a fundamentally unfair trial, which is basically correct. Thank you, Brian Gibson, for the 10 gift memberships. It is extensively appreciated. I really do appreciate all your support. I appreciate every one of you who's here. I hope I'm giving you a good quality stream. I try very hard. I'm not sure how to do better quality streams. I only say that because some other people covering streams tend to do better than me historically. And I'd like to be the best streamer I can, but I'm not sure what would take to accomplish that objective. But I do my best, and I appreciate those of you who are here and spending time with me. It's nice. But we'll discuss more about what I could do as a streamer at the end of the stream. Court-ordered witnesses. Defendant will need to submit a more detailed motion delineating the witness she seeks to summon for trial and anticipated costs, requirements for the JAC due process contract. If any provider desires direct payment, the JAC procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain the payment. Because of unusual circumstances present in the matter, JAC requests to participate in the hearing. JAC requests to appear through communications equipment and can be reached toll-free at this number. And therefore, we give certificate of service that the true and correct copy has been sent by facsimile, email, or otherwise to both Sarah Boone and to the state. And that is the end of that thing. Okay. I'm not sure what kind of expert would help her. I don't know what would help her. A mental health expert would be the most obvious thing. If we can find an expert that can somehow testify that she was of some sort of diminished capacity, that would be really helpful. But other than that, I don't know. So that's the end of that stream. So there's that. You only YouTuber about to go through the whole thing? Appreciate that. Thank you. So most of their motions will be denied because there's not enough information. And she didn't ask for a continuance. And so that was the big mistake, not asking for a continuance. It would have been denied too, but she should have preserved the issue. Seeing that voluntary intoxication is not a defense, she's effed. Yeah, you'd have to make it through some other means than the intoxication itself. So you'd have to get there some other way than the intoxication. You'd have to say that she was insane for some other reason, which I'm guessing is not necessarily impossible, given some of her letters. I mean, it doesn't seem like it's necessarily that far-fetched to suggest there might be reasons other than alcohol that might have contributed to potentially her having some sort of diminished capacity. That doesn't seem like a completely frivolous argument. I'm not sure what evidence is available for that proposition, but given her writings and overall behavior, it seems like a plausible inquiry, regardless of how it would ultimately pan out at the end. Yeah. I don't know if I was surprised is exactly the right word, but I was slightly dismayed, and I'm not going to lie. I was slightly dismayed. Um, I think it was in even Peter's chat, Lawyer You Know's chat, where I said, well, I thought, as to the ballerina, I thought she was guilty because I didn't believe her. And Peter was very nice to me and cordial as he always is. But there were like 2 or 3 people in the chat who were like, well, Uncivil Law believes she's guilty. Well, no wonder. He doesn't believe women, or he doesn't like women, or he's an incel, or, ghost figures. And it's like, I don't know how to deal with that, because I don't think it's true. I just think it's my assessment based on the information. I mean, with respect to Karen Reed, for example, I think she's not guilty. And, so I obviously, and there was Potter, the police officer, for example. She was a woman. I thought she was not guilty. So I don't think it's a fair characterization. I don't think I have anything against women. Perhaps I'm not willing to give them anything more than I'd give a man, but it's like, I don't know how to necessarily deal with this issue. And I lay out all my reasoning, and I lay out all my thinking, and people are still like, basically making fun of me and making names at me. And I don't like it very much. I don't think it's fair. And it all comes down to credibility. It all comes down to her, because it's fundamentally a one in the ballerina case. It's fundamentally a one witness case in the end. And fundamentally in the end, it's a one witness case, because the defendant is the only person there. She's the only person that can provide any testimony as to what happened. Right? And we can use things that happened prior or external, or to shade the probabilities of those things. But fundamentally, she's the only witness that's available. And so whether you believe her or not kind of is the end of the game. I think you could also believe her completely and also believe it's not legally sufficient. But, whether you believe her or not is the end of the game. And I don't know how to go about addressing that without saying, well, here's why I didn't believe her. I found her behavior on the stand to be performative. I found her behavior on the stand to be overwrought. I found her performance on the stand to not be genuine. When she was fine crying, I found it to be fake crying, because there were no tears, there was no swelling, there's no puffing. There's nothing that indicated, to my mind, genuine emotion. It didn't seem real to me. When she was down testifying about the stance, she was unable to replicate the stance. She's like a fighting stance, but she couldn't even replicate a fighting stance. She couldn't say what he looked like. When he said whether it hit her or not, she couldn't say if it was open fist or closed fist. The photos of her didn't seem to show any damage that I could see at all. If there was damage there from being hit, it was so subtle as to be confusable for nothing at all, at least in my mind. So it's like, okay, here's what I'm basing that on. Here's how I'm assessing it. It's like, what more can I do other than lay it out? And you can disagree with me, because it's incredibly subjective. It's incredibly subjective, because we're basing it based off our perceptions of her, as opposed to any evidence that would back her. There is no external evidence that backs her. So it's incredibly subjective. So I don't know what more to do in such cases. But I really don't like being accused of being anti-woman. I don't like really being accused of being a misogynist. I really don't like being accused of being an incel. I'm just trying to think. And I'm also trying to apply principles equally. When I do my best, like, okay, so if this were a man, how would we feel? Okay, should we feel differently because it's a woman, and so forth? Like, trying to apply principles as equitably as I can. I don't know. You think it's the DV of the case, and many people are triggered from personal experience. Fair. Fair. Yeah, let things roll off your back and they won't troll you. That's easier said than done, a little bit. I am I am sensitive to the perception of me because I want to be seen. I want to be seen as fair, educated, logical, well-thinking. I want you to see my thought process. I want you to understand it. I want to walk you through it. I want to show you it in steps so you can follow me along the way, so you can track me. I want to be a good educator. And people's perception of me matters to me. So did the super chats go through? I think they did. I thought I read them all, but if not, let me check the funding tab. Oh, I kind of missed some along the way. Apparently, according to YouTube's chat summary, apparently viewers are discussing the Megan Fox trial verdict and the jury's decision not to convict. Well, that's an exciting revelation. Thank you, YouTube, for that exciting commentary. Manny Strong gave me $4.99 to say on the X post. I gave you the JAC response. We read it. Judy M has been a member for 10 months, and Honest Doubter's been a member for 18 months. Will Newman, Jughead Jones has been a member for 1 month. And Mandy Strong gave $4.99 to say it's funny how Smart Pants Sarah forgot to file the motion for continuance. That's a pretty big oopsies. Lug Moose Meister, been a member for 18 months. Molly Rocket became an uncivilian. Thank you for hitting the join button. We appreciate everyone who does. Andrew Maggart says, still waiting for the uncivilian legal mindset defense team to come to the rescue. Mandy Strong said she could have the prosecutor zip her up in the suitcase and Sarah could show her how George could have been able to get out. Kissy Kissy gifted 10 gift memberships. Mandy Strong gifted 5 gift memberships. Fanny Pack gifted 10, or apologize, has been a member for 10 months rather. Mandy Strong for $1.99 says she's going to drive the judge to drink heavily. Pretend Judge gave $2. Pretend Judge gave $2 to say, never fear, I'm here. Chuck in Tennessee has been a member for 21 months. Chuck in Tennessee for $5 says, PBL means punishable by life. That classification of felonies results in no bond for the offender. Thank you. Brian Gibson gifted 10 gift memberships. Chuck in Tennessee gifted 10 gift memberships. Logmeister gifted 10 gift memberships. And Rebecca Zarkowski. Now I know how to do this. Rebecca Zarkowski. Rebecca Zarkowski. $4.99. Afternoon. May it live. Hope you're well. Insert Tiger Paw here. Thank you, Rebecca. Zach Ruski. Damn it. Didn't get it right. Shit. Yeah. Apparently now viewers are arguing the Depp v. Heard trial, according to Google. That's interesting. Has anyone in chat even mentioned the Depp v. Heard trial? I'm not sure on what basis Google thinks we're discussing it. Here's a tacit positive vote for you. That's 375 votes for you being against, some 1 to 2 dopes being negative. Thank you. Sweet Pea for $10 say it's speculated Sarah knocked George out with a baseball bat, part of the evidence, and then put him in there. Neighbor said SB and George were fighting all evening, and then it got eerily silent. Well, if she hit him with the baseball bat, that would definitely do the trick. Yeah, that was one comment. Yeah, that was one comment. Yeah, no, really. It's like, I'm not sure how you came up to these conclusions. Since when do we execute men for being jerks? We don't. We either have laws or we don't. Yeah. I think it's helpful to try to look at things from different frames of reference. I'm not sure that everyone in chat would have, I don't know for sure, but I have a sneaking suspicion. That if everything were exactly the same about the case, but the genders were reversed, that Melanie Little's chat, for example, would not have had the strong feelings they did. I think some of them would have, but I think other people would not have. I think the sexes do influence people's perceptions of that. So if the ballerina had been a male ballerina and had been the victim of domestic violence by his wife, I'm not sure they would have necessarily felt the same way about it. Many of us saw you snap at Megan Fox. She deserved it, though. She deserved being snapped at. I didn't snap at her for being a woman. I snapped at her because she's a horrible person. She is a horrible person. Along with what's her name? Fair and Balanced. You're say I'm looking great. Thank you. I'm on day 3 of keto. It's going surprisingly well so far. We'll see how long I can stick with it this time. I'm gonna give it a go. Eggs, my friend. Scrambled eggs is what I'm choosing basically for my principal diet food. Because scrambled eggs are fat and protein and no carbohydrates. They're great. Plus, they're relatively inexpensive. So I can get lots of them and eat cheap. Neat. You throw in a little Spam, some salt and pepper, some hot sauce. It's great. Yeah, I believe all woman has put a lot of innocent people in jail. It's like, yeah, people say like you're blaming the victim. It's like, no, I'm disputing that she is a victim. You can only be blaming the victim if you think she is a victim, which is the very thing we're trying to establish in the first place. Is she in fact a victim? So it's like, yeah. Shrimp are great for keto. Spam, you should not be left unsupervised. Spam is fine. I get the bacon infused Spam. It's great. But it's fine. It does the job. It's tasty. You got sick of eggs real fast? Well, so far I'm doing good. So far, so good on the egg fast. I'll let you know how it sticks. Tomorrow in the groceries, I'm getting some no sugar added peanut butter so I can add that to some smoothies. That'll be nice. Along with my protein powder, so that'll be nice. So I can have some peanut butter smoothies. That'll be pretty badass. Along with some Phage yogurt, 5%, good shit. So that'll be good. I'm getting more eggs and some cheese, and then other stuff. I think powdered peanut butter. I do have powdered peanut butter. I have that too, but I actually want the real peanut butter because I want the bulk. So I do have powdered peanut butter for flavoring. So I do have that, but I want real peanut butter because I want the creaminess and I want the volume. I want my peanut butter. I will not be denied. You can't make me not like peanut butter. I want peanut butter, damn it. Speaking of which, I might have to have food pretty soon. Add some oil to the peanut butter powder and you got peanut butter. I suppose that's one way you could go about it. I mean, it's not quite the same, but okay. How about this? How about this? How about this for an idea? What if, and hear me out, what if I just bought jars of peanut butter and I use that and put that in my smoothie? I know. It's a radical plan. I am getting the low sugar ketchup. I'm getting low sugar ketchup too. Nutella sounds good, actually. I should have definitely got some Nutella. Oh, I could add it, actually, because it's not being delivered to tomorrow. I could get some Nutella and throw some Nutella in there. That's actually a really good idea. You could put actual peanuts in the blender, too. Fair. That is extremely fair. That is extreme. Maybe I should just buy peanuts. Maybe I should just buy completely unsalted peanuts and just throw that in the blender. That is a pretty solid point. Nutella has sugar? Okay, not so much with the Nutella then. Okay, not so much with Nutella then. Should I just buy peanuts and then grind those up? That'd probably be cheaper, right? It's got to be cheaper than peanut butter, right? Just raw peanuts is probably cheaper, right? Than peanut butter? Probably. Yeah. Maybe I should just get peanuts. Recommend you don't drink your calories. Just have something for a break, man. Just something different. But it's keto, so it's fine. Just get the peanut butter. Cool. All right, I'll just get the peanut butter then. Eat less and move more. Yeah. Hard-boiled eggs. I've never really been successful at making hard-boiled eggs. I always seem to underdo them or overdo them. I'm not good at making hard-boiled eggs. I'm pretty decent at making scrambled eggs, though. So I got that going for me. I could probably make hard-boiled eggs in my Instapot, though. All right, I'm going to sign off for now. I'm a little tired. And I've enjoyed chatting with you. It's been fun. It's been real. So I'll let you know how it all turns out on it. So, yeah. Unsalted, unsweetened dark chocolate. I mean, I could throw some of that in there in the mix. Unsweetened dark chocolate. Maybe I'll get some unsweetened dark chocolate and throw that in a mix. I'm not a huge fan of dark chocolate, but I don't have to necessarily put a lot of it in there. I could just put like a little bit in there and it would be fine, maybe. Could be good.